Hello everyone, in this video I will be talking about the welfare principle, in the context of family law UK. So what is the welfare principle, you must be wondering. The welfare principle is found in the Children Act 1989, and under Section 1 subsection 1 it states that when a court determines any question with respect to a. the upbringing of a child, or b. the administration of a child's property, or the application of any income arising from it, the child's welfare is the court's paramount consideration. So, what this means in practice is that the welfare principle is the core principle of family law UK, as the child's welfare must come first, above any wishes of the parent or any other party involved. And this applies in situations under subsection 4 where the courts are making, varying or discharging orders, which include child arrangement orders, which involves who the child lives with or sees, care or supervision orders, special guardianship orders, and any financial situations where children are involved. The welfare principle also includes that, under Section 1 subsection 2 of the Children Act, that in any proceedings in which any question with respect to child arises, the court shall have regard to the general principle that any delay in determining the question is likely to prejudice the welfare of the child. So what this means is that the court should avoid unnecessary delays when making decisions about children, as prolonged proceedings can be harmful to the child's emotional stability and overall welfare. The welfare principle also includes that, under Section 1 subsection 2a, Children Act, that a court, in the circumstances mentioned in subsection 4a, is as respects each parent within subsection 6a to presume, unless the contrary is shown, that involvement of that parent in the life of the child concerned will further the child's welfare. What this means in simpler terms is that in most cases, the court presumes that it is beneficial for a child to have some level of involvement with both parents, unless proven otherwise. This involvement could either be direct or indirect. Now, referring back to subsection 4, which involves the courts making, varying or discharging any of the orders mentioned previously in respect of children, they can refer to a list of key factors known as the welfare checklist, found under Section 1 subsection 3 Children Act 1989. This includes the ascertainable wishes and feelings of the child concerned, considered in the light of his age and understanding. So, what this means is that when a child expresses his wishes and feelings, for example who they would like to live with, will be taken into account by the court. However, the weight given to those wishes and feelings will depend on the level of the child's maturity and age. Next, his physical, emotional and educational needs. This includes basic needs like shelter, food, emotional stability, mental health, and access to proper schooling. Next, the likely effect on him of any change in his circumstances. What this means is how the specific decision will impact their well-being, which includes moving homes, changing carers, schools, or routine. The courts will need to prioritize stability when making such decisions. Next, his age, sex, background and any characteristics of his which the court considers relevant. This may include cultural, religious, linguistic, or any other individual characteristics such as a disability which the child has which need to be taken into account. Next, any harm which he has suffered or is at risk of suffering. For example, if one of the parents or carers has a history of violence, the court is less likely to give weight to that individual's wishes and feelings regarding the child. This is to safeguard the child and prevent any risk of harm. Next, how capable each of his parents, and any other person in relation to whom the court considers the question to be relevant, is of meeting his needs. This involves assessing whether the parent or any other relevant individual is capable of meeting the child's financial, emotional, and physical needs. Lastly, it includes the range of powers available to the court under the Children Act in the proceedings in question. This refers to the various orders the court can make concerning the child's welfare, as previously discussed. The last thing to consider in the welfare principle is that, under Section 1 subsection 5 Children Act 1989 it states that, where a court is considering whether, or not to make one or more orders under this act with respect to a child, it shall not make the order or any of the orders, unless it considers that doing so would be better for the child than making no order at all. So, what this means in simple terms is that the court should not make any orders involving children unless it positively benefits the child's welfare. This is to ensure that the courts do not unnecessarily interfere in the child's life and family matters. Thank you for watching the video. Before ending this video, I would like to mention that the welfare principle does not apply to emergency protection orders. This is because these orders prioritize the no-delay principle, and requiring a full welfare analysis in urgent situations could place the child at further risk.